Hello, this is Matt on the Moon Lambeau channel. The SEC warns it will delay the SEC v. Ripple lawsuit yet again, but it will only have the ability to do so if Judge Torres allows it. And that's because anytime they request a special extension, anything along those lines, the judge has the final say on that. And I'll explain why this is even coming up right now, but that's not the only concern here. Perhaps even more disappointing is that, and this isn't Brad's fault, but Ripple CEO Brad Garlinghouse issued a new warning, literally yesterday, that it's possible the SEC lawsuit will drag on, perhaps not ending until June of 2023. So I'll explain to you what he said in full context, and Attorney John Deaton also had something to share on that topic as well. So plenty to discuss in this latest Moon Lambeau Hot Jam. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now let me do a little bit of table setting here, make sure everybody's caught up to speed. There was a tweet from James K. Filan, who of course is an attorney within the XRP community, and he shared this from the SEC on September 19th, so just a few days back. And I briefly covered this on a video right after this popped up, but just make sure that everybody is aware of what the SEC filed. They sent this to Judge Torres. Reads as follows. Dear Judge Torres, the SEC respectfully submits this response to the motion by the Chamber of Digital Commerce for leave to file an amicus brief. So I'll just pause to note the Chamber of Digital Commerce requested the ability to file a brief stating, just as purely as a third party, their perspective on what's happening in the SEC v. Ripple case, just like Attorney John Deaton is representing somewhere in the neighborhood of like 73,000 XRP holders. Anyway, and then the SEC assets continue, and they say, the SEC takes no position on the motion, but respectfully requests that, in the event the motion is granted, the SEC be able to respond to the motion as part of its brief in opposition to defendant's motion for summary judgment. And here's the part where it gets problematic. The SEC may seek further relief from the court, including additional time for its response and/or additional pages for its October 18th opposition brief in the event additional amicus curiae briefs are allowed. So that's the part that was directed at Attorney John Deaton. They're saying, okay, well, if these friends of the court, these amicus parties, if they're allowed to file briefs, we're going to need more time. We need to delay, which is their MO. That's been the story from the beginning. And so on that day, Attorney Filan said, the SEC says it takes no position on Chamber of Digital Commerce filing amicus brief, but asks to respond and may request more time or pages if additional amicus briefs are allowed. That last line is clearly a threat directed at John Deaton. And so note, the reason that we know that is because the Chamber of Digital Commerce, that's already addressed in this damn letter. The only other amicus party would be Attorney John Deaton. So they're saying, if another one's filed, so right there, that's what he's talking about, which is it just kind of grinds my gears. And then somebody named XRPL Fawcett wrote in response to that on Twitter, John Deaton, tag John Deaton there, you said you would file after reading Ripple's opposition, but this suggests you need to file before then? And Attorney Deaton retweeted that, and this was also on the 19th, and then John wrote the following. I can't file anything until I read the exhibits attached to the briefs, which are currently sealed. This is the SEC sadistically trying to cause panic among XRP holders who will read this and think a significant delay. I have plenty of time, and our brief won't cause a delay. I've never seen an agency with such disdain and contempt for the people they are supposed to protect. It's utterly disgusting, and they should be ashamed of themselves. Yeah, and so to be clear here, what John Deaton is saying, of course, is accurate. He's not going to slow down a damn thing. It's the asshats at the SEC, if anything, that may request additional delays because they're just terrible creatures that nature accidentally made, so far as I'm concerned. Which leads us to the brand new part of what's going on. There's actually two brand new, or maybe maybe it's all included here. Whatever. The headline from you today is Ripple calls out another transparent attempt to delay case on part of SEC. And so the letter, so this is the brand new one, and that story is from the 21st. This letter was from the 20th. And then, yeah, so there is another one after this, actually. But check this out. Check this out. Dear Judge Torres, my gosh. Well, actually, let me just read James Filan's summary here. He wrote, Ripple defendants object to SEC suggestion that the SEC will seek additional time or pages if other amici curiae submit briefs. And so Ripple, this is Ripple saying it is completely unacceptable for the SEC to be even bringing up the idea of having additional time. So here's what they actually stated. It's so short I can just read the thing for it. It's on your screen for those of you that care to look. Dear Judge Torres, defendants Ripple Labs Inc., Bradley Garlinghouse, and Christian A. Larson respectfully submit this letter in response to the Chamber of Digital Commerce's motion for leave to file an amicus curiae brief, and the SEC's response thereto. Defendants take no position on the Chamber of Digital Commerce's motion. We write, however, to address the SEC's suggestion that it intends to seek additional time for its opposition and additional pages if other amici curiae submit briefs. So again, pause. That would be John Deaton. So that's who they're talking. There are no other amici parties. Okay, you got the Chamber of Digital Commerce and John Deaton. Okay. Anyway, Ripple's legal team continues, and they say, this is yet another transparent attempt to further delay resolution of this case, and the court should reject it. It is no surprise that multiple amici curiae seek to submit briefs in this case, given that the SEC's novel and overbroad theory threatens an unwarranted expansion of its regulatory authority beyond what Congress permitted. Indeed, that was clear long before the court set the summary judgment briefing schedule in this action, granting 5 individuals permission to participate as amici curiae, counsel for amicus curiae, Chamber of Digital Commerce moving for admission pro hoc vice, and so they're referencing the parties there. And then they wrote, noting enormous public interest in this litigation. It was clear long before the parties proposed and the court set page limits for their briefs as well. Courts do not ordinarily grant parties additional pages to respond to arguments made by amici, even in cases with significant amicus interest, providing no allowance for extensions to respond to amicus briefs. The SEC is free to use the already allocated space in its opposition and reply briefs to address arguments raised by amici, and to do so on the already established briefing schedule, just as defendants are. The court should not countenance the SEC's request. So that's it. And then there's a second page, but here I'll show you. It's just signature lines. So that's what was stated. Now, in response to that, Attorney Jeremy Hogan said something quite simply, just on point, but short. He wrote, it's cool that the SEC is so much more afraid of 74,000 people than it is of all the chambers and organizations and associations in the world. There you go. Because again, it was a threat aimed towards Attorney John Deaton, intended to scare XRP holders, right? So it couldn't be more clear. Like, obviously, it's been clear from the beginning. The SEC literally was pushing back, arguing that it made no sense for the, now, according to Jeremy Hogan, there's 74,000 XRP holders be included in this case. And the SEC, they had the audacity to claim a year and a half ago, when this was all going down, that it didn't make sense to have the XRP holders being represented because their views aligned with Ripple already. And then as that was happening, I'm sitting there thinking, wait a minute, you're arguing, and they literally did argue this. They argued that XRP holders' views align with Ripple, so there's no need to have them as amici curiae, friends of the court. And I'm sitting here thinking, as they're announcing, I'm like, what in the ever-loving hell are you talking about? Our views aligned with Ripple? You said that they wronged us, and you're protecting us. You represent us, SEC. That's your claim, right? But then they start claiming that Ripple and interests of Ripple and XRP holders are aligned. I don't. The whole thing's just been a freaking train wreck. So it is what it is. It really steams my vegetables, son. And then there's this. This is a real quick thing. I don't even really need to read this, but Attorney Filan, and shout out and credit to him, he shared this, so this is the latest. The court has reviewed the request by the Chamber of Digital Commerce for leave to file an amicus curiae brief and the parties' responses, and has granted the chamber's request. The order and brief are below. And I'm not going to read it, but that's what's on your screen. It's super short. It's a couple sentences. That's all that it is. Now, check out this, because this is where it gets to the part where, according to Ripple CEO Brad Garlinghouse, who would be the most in-the-know guy in terms of timelines here, right? Because he's a defendant. He's actually a defendant in this damn thing. He's got great legal counsel. He was on stage speaking with Ryan Selkis, who is a noted Ripple and XRP hater, who's just has the most bogus, irrational arguments. I've highlighted his arguments over the years. It is what it is. But that's not the reason I'm bringing it up. I'm just mentioning where this took place. And this is literally yesterday. And XRP Crow, XRP community member, wrote this quote, and this is from Brad Garlinghouse, literally yesterday. He said, by mid-November, we should have the motion for summary judgment fully briefed in front of the judge. Then the question is, how long does the judge take to make a ruling? It could be 2 months or 6 to 8, 9 months. Again, that's a direct quote from Brad Garlinghouse. So there's no guarantee, and it's not like he wasn't pretending. Nobody's pretending to know exactly how long this is going to go. But there is a chance that we could be talking about this next summer and being like, when's this going to be over? I mean, you're talking about fully 2.5 years of everyone's lives sapped by the SEC. 2.5 freaking years potentially, according to Brad Garlinghouse. That's what it would come down to. And so here's what Attorney John Deaton had to say on that. Brad said something XRP holders don't want to hear. He said a decision from the judge could be anywhere between 2 to 9 months. He clearly has asked his lawyers. No way it only takes 2 months. The earliest will be end of March. I think it could take until late April/early May. So that's his best guess. So acknowledging, yeah, it could go to June, but his best guess, it sounds like more like April or May. But my gosh, these are the latest potential outcomes I have ever heard in this case. And when it comes from Brad Garlinghouse, like, my ears perk up. I'm like, I'm listening. I listened to that whole interview. It went for a half hour. And shout out, by the way, and credit to Brad Kimes, my fellow XRP YouTuber, because I put out a tweet and I was like, where can I find this thing? Because I wasn't able to watch it live as it was happening in the afternoon. And then he responded and let me know that he actually had the whole damn thing up on his channel. So I was like, oh, thanks. So I checked the whole thing out. So shout out and props to Brad Kimes. Much appreciated. So again, look, it doesn't mean that this is what's going to happen, but man, this, like, even the potential there, it's just, I want this damn thing to be over. But look, I'm still optimistic for a positive outcome. And the reason that I will say this, and this is just admittedly just a dude on the internet speculating, but I don't think that's likely. In fact, I still personally think what's most likely is settlement because of what's in those Hinman emails that the SEC doesn't want us to find out about. And I think that Judge Torres is going to rule, and along with Judge Netburn, and that's going to start the clock for when the SEC is going to be like, they're either going to have to eventually hand this over, or they're going to have to settle. There's really no other choice, because they can't just choose to not hand it over when the judge says that. Eventually, it's going to wreck their case. And there are legal reasons, right? They literally can't just be like, they can't just be in order. You must hand this over, and then they don't comply. That won't work. They will ruin their own case, which is why I keep saying, in terms of what's probable, that's still my best guess. It doesn't mean it's going to happen. There could be full adjudication. I do acknowledge that, but that's not what I think is most likely. So we could still have a happy ending, whether it's late this year or early next year, whatever it is, that could potentially happen. I'll go ahead and wrap up there, but please let me know what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.